So, you know, it's a fascinating time, it's a fascinating subject. If you think about it, in our day, we've got a couple of really major keystone issues going on right now that we're all living through and we're all watching develop. The gay rights issue is huge. It is happening across the country. It's changing. We saw the Supreme Court refuse to intervene. In one case, we saw them strike down another case. So we're watching the gay right, the right to marriage, mold and form before our eyes. There's a host of other issues. Although it seems to have taken a back seat to what's been going on lately, the abortion issue continues to be an evolving, active, dynamic issue that has impact for each and every one of us. And I would say, even though I'm leading the fight in this in 2 states, the gun issue is huge. It is huge. It is perhaps the defining issue right now in our country. It invokes an incredibly passionate reaction. Whether you're for it or against it, it is a hot button item, and it continues to dominate the press, the media, and our lives, particularly in the state of Connecticut, where the tragedy and the horror at Newtown was a game changer. So this is an issue that is divisive and bubbling up and captivating. And it's fundamentally important. It is fundamentally important. And I think what Rachel was getting at, and what you guys really, what's really cool, whether you're a gun person or not, and everyone has the right to be whoever they want to be, right? Whether you're a gun person or not, the issue is being actively formed and shaped right now in 4 states: Connecticut, New York, Maryland, and Colorado. These 4 cases, the cases that are going on in these 4 states, are going to shape, I believe, at a federal level, at the Supreme Court level, how this issue continues to evolve. And you're looking at the architect right there. Right there, this guy. So this is, I mean, when Rachel says in her very humble way and talks about Chris Conte as a guy who's a part of it, it's a little bit bigger than that. You know, because Chris, through the NRA, and again, this is an organization that invokes an incredibly passionate reaction in people. Chris and the NRA-ILA are shaping, are actively litigating this issue up through the courts, and that's the only way this particular issue takes shape. Why? I don't know. I don't know. When Chris talks about the Civil Rights Act, you know, that was, I want you guys to understand what that means. There is a right that evolved. It evolved through decades of court litigation. A lot of it unfavorable. A lot of it taken on the chin at the trial and appellate level and had to be pushed up and fought case by case by case over the years, up until the Supreme Court made a declaration about it. And then, in the wake of that declaration, Congress acted. Congress acted legislation, enabling legislation. So you have this right that exists because either the Constitution says it exists, or the Bill of Rights say it exists, or the Supreme Court says it exists, and then what do you do with it? You need an enabling body of legislation, enabling laws, regulations that protect the right and exercise the right and give it meaning every day in your lives. And without that kind of regulation and administration and legislation, the right means nothing. The Civil Rights Act of 1964 was the enabling legislation to these landmark cases that we saw in the Warren-era court. Because they came out with these incredible decisions that advanced fundamental rights for everybody, mostly in the area of civil rights for persons of color. But were these landmark decisions that pushed the ball forward, and then Congress reacted. They gave enabling legislation, forming laws, furthering the rights, detailing the rights, giving people remedies if the rights were violated. Do we have that with the Second Amendment? No, we don't. Why? I don't know. We don't have it. So these cases, the right gets shaped and formed and developed through the litigation, and this guy right here is the guy who who controls it. Now, I'm not saying Chris runs the NRA. He's extremely important in the organization, and that is how the right gets moved forward. Love it or hate it. Your choice. You're allowed to choose. You can have your own opinion about it, but love it or hate it. That's how the fight gets fought. Now, I happen to be lead trial counsel in 2 of those 4 cases. Chris has been we've worked together. Chris is my friend. We've known each other for a long time. And he has brought me up into the ranks of, now on a pretty good trial team, where I'm leading the trial team with some guys, and we're attacking the law in New York, the SAFE Act, and the Connecticut Act. So, what are we doing? Well, the Second Amendment says, let's begin with a discussion of what the right is, then we'll talk about what the fundamentals of the law are, then we'll talk about the case and what it's doing. Second Amendment, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. What does that mean? Well, for decades, the Supreme Court interpreted that right to be associated only at a federal level, not as an individual right, for you, or for you, or for you, or for me, but only attaching to people who are active in the military, in the militia. Why? Because the notion, the historical notion was that militias were designed to protect individuals against anybody. Against?
Foreign powers.
The government. No, not
Tyranny.
Tyranny. Tyranny. Tyranny of what? Tyranny of your own government. Why? What would happen? Because King George, in the colonial era, had this neat way of defeating his enemies. How would he do that? He would disarm them, and then he would kill them. Great, right? Want a political opponent? Not if you're dead. The idea was the right attached to militias who were designed to protect citizenry against the tyranny of their own government. That sentiment still exists today. It is extraordinarily strong. It is not some paranoid, kooky, I'm a guy out in the cabin in the woods kind of thought. It informs the thought, action, and belief of a major segment of our society. It is vibrant, it is important. With Heller, the Supreme Court deviated from that notion. And they said this, that the right is not associated with service in the militia. The right is an individual right. It attaches to individuals. You don't have to be in a militia before you have this right. It attaches to everybody. Law-abiding citizens, being everybody. All right? It can be reasonably regulated, but it is a right. Heller, it is an enumerated right, it is an individual right. What kind of firearms is it attached to? It attaches to firearms that at the time of the writing of the Bill of Rights were in common use at the time, and therefore attaches today to firearms that are in common use. Okay? Common use at the time. That argument was a refutation of the notion that if the Second Amendment was written in the 1700s, the right, and I apologize, ladies and gentlemen, I don't know the exact date the Second Amendment was passed or ratified or written, but if it was written in the colonial era, it only protected firearms that were common at that point in time that the framers understood. Not so, says the Supreme Court. No, what that meant was it was for weapons commonly used by the militia for them. Meaning, if you were a militia member, you were expected to bring your own arms. A militia is not a government force, it's a private force. And it was expected that people who populated the militia would bring their own arms with them. So the phrase common use was for people, the weapons commonly used by members of the militia, and therefore weapons commonly used today. That was articulated further by Justice Scalia to say the right protects arms typically possessed for law-abiding purposes, for lawful purposes. Common use, typically possessed for lawful purposes. Heller left more questions unanswered than it answered. Heller says one thing. It's an individual, it says many things, but the core message of Heller is this is a fundamental right. In the specific facts of the Heller case, that involved a special police officer who had applied for a permit, was denied, and the regulations pursuant to which denied basically outlawed the possession of handguns in the home. It said you could have them, but they had to be unloaded, they had to be locked, they had to be trigger locked, and it effectively barred the use of a handgun in the home. So the Supreme Court, in the fact-specific context of the case, said any regulation that amounts to an outright prohibition on handguns in the home is unconstitutional because you have a core right to use handgun, the firearm of choice for the majority of Americans. You have a core right to possess a handgun in the home for defense of hearth, home, loved ones, property. So Heller identified a core right, and clarified that the Second Amendment right is not attached to militia service, but is an individual right. What questions did it not answer? Is the right fundamental? And does it apply to the states through the 14th Amendment or some other mechanism? Understand, we are a federalist society. We are 50 states, 51 states, I'm sorry. We are states with individual governments protected and unified by an overarching federal system. That tension between state and federal is called federalism. It is a guiding principle of our country. In a federalist society, there are federal laws, there are state laws, there are local laws, ordinances, and regulations. For the longest time, the Second Amendment, with a dwindling number of other constitutional rights, was deemed not to apply to state action, but only to federal action. It wasn't a state-protected right. It was a right against infringement by the federal government. It only protected rights to be impacted or infringed by the federal government, not the state government. Meaning, the federal government couldn't take action to a certain level against the Second Amendment right, but states could do whatever they wanted. Okay, you guys get that? State, federal. Second Amendment for the longest time was only deemed to be a federal right, therefore protected only against infringement by federal action, not by state or local action. So, Heller did not answer the question of fundamental. It did not answer the question of whether this right applied to the states against state prohibition through the Due Process Clause or some other mechanism. McDonald answered both of those questions. So, along comes McDonald versus City of Chicago. Different case. Guess where it came from? And McDonald answers the question in the affirmative. This is a fundamental right. Therefore, it is elevated. It is elevated to the same level. Would you guys know what rights are in the Bill of Rights and what rights are fundamental versus not being fundamental? Okay. It might surprise you to learn that not all of your constitutional rights are fundamental rights. You have a fundamental right to freedom of speech, freedom of association, the free exercise of religion. You have a fundamental right to freedom of press. Do you have a fundamental right to a jury trial? Do you have a fundamental right to cross-examination? Do you have a fundamental right to vote? Do you have the fundamental right against suffrage? Do you guys know? Interesting questions. Not all of these rights are fundamental. Did you know that? Interesting. Fundamental rights have been established as such by the Supreme Court over decades and decades and decades of litigation. And they have articulated those rights that, in the Bill of Rights that are deemed to be fundamental. It is the majority of the rights. For the longest time, the Second Amendment was deemed not to be a fundamental right. With McDonald, the Supreme Court clarified that the right is fundamental. It applies against both federal and state action. It is incorporated, in other words, through the Due Process Clause of the 14th Amendment, as opposed to the Privileges and Immunities Clause of that same amendment. And therefore, it is sort of, this is my word, not theirs, it is in the pantheon of rights. Why? What makes it fundamental? It pre-existed the drafting of the Constitution. It wasn't something that was created by the founders back in the 1700s. It exists before that. It pre-exists the creation of our country. It's this notion. It's a fundamental notion of freedom, fairness. It is an elevated right. Okay? So, that means it gets special protection. It gets a level of scrutiny by the court when it is infringed that is almost virtually impossible to withstand. So very briefly, when there's a constitutional right, a right that's found in the parameters of the Constitution of the Bill of Rights, and that right is violated by some state action or law, the level of scrutiny that a court will look at it when someone challenges that right, says, hey, look, you know, the city of Bridgeport is not allowing me to hand out my pamphlets in front of the courthouse. They have a regulation that says I can't do that. I say, Mr. Judge, that right is violating my First Amendment right of free speech. When you bring a suit that challenges that violation, you want the court to look at that on what we would call strict scrutiny, or the highest level of scrutiny, saying, in order to be constitutional, this law has to be strictly tailored to meet a compelling governmental interest. Very few laws, I don't think there's any, that could ever satisfy that burden. So if you get a court to apply strict scrutiny, you win. On the other hand, if the right involved isn't fundamental, if it's, I don't know, the right to smoke a cigarette in public, the right to wear a motorcycle helmet or not wear a motorcycle helmet when you're driving your vehicle, of course I'm going to say that's not a fundamental right. I'm going to look at that with something less. I'm going to call it rational basis review. And basically, as hard as it is to survive strict scrutiny, it's that easy to survive rational basis review. In other words, all the defender of the legislation has to come up with is a rational reason that's rationally related to a legitimate governmental interest. So there's this extreme of tests that you want the court to look at and trigger depending on which side of the litigation you're on. In this case, we now have a court decision saying the Second Amendment right by the Supreme Court is a fundamental right, and therefore any infraction of that right, any imposition of that right by legislation or action by a governmental body triggers the highest level of scrutiny, and that's what we're trying to do in Shue versus Mulvey. So, with that said, I want to know if you got, I'm going to ask, it's important not only to know, I'll give you the basic outline of the law, now I'm going to ask you a couple of facts. Understand, we're claiming that we have a fundamental right that's been violated. Understand that we are seeking to have the court strike down this legislation as unconstitutional under the Second Amendment and strict scrutiny and the dictates of Heller and McDonald. Okay? So, we have a factual scenario. We begin with the reality that we're bringing this litigation and in a state where the law was triggered by what event? You said Newtown. Okay? Is this the only event of this nature that's happened in the last 2 years? What we got? We got Aurora.
Show was the past 2 years, right?
We have the shooting of Congresswoman Gabby Giffords.
Yep. We
have Binghamton. We have, in more distant memory, Columbine.
Fort Hood.
Fort Hood.
Virginia Tech.
Right. Virginia Tech.
Show.
Right. Wow. A lot of people get killed with assault weapons, right? Right? Wrong. Wrong. Assault weapons account for the majority of murders in this country over the last 10 years. Right? Wrong. Assault weapons are the weapons of choice for criminals and madmen like Adam Lanza and Holmes, Mr. Holmes, and Jiverly Wong, who killed 13 people in Binghamton before killing himself, and the madman in the Navy Yard who just shot and killed, I think, 12 people, and then was killed by the police. Assault weapons are the weapons of choice for people like that. Correct? Wrong. Wrong. Assault weapons are rarely used in crime. Assault weapons account for 1%, perhaps 2% of all crimes in this country, according to statistics generated by the NRA, right? Wrong. By the FBI, by the Bureau of Justice. They don't have a gun, they don't have a dog in this hunt. They have no axe to grind one way or the other. You can go back 10 years, you can go back 20 years. And the undisputable facts show that assault weapons in crime account for less than 10%, more like 1 to 2% of all crime, historically going back 20 years. 20 years. Rifles and shotguns, they account for the significant percentage of crime in this country. Correct? Correct? You don't know? No. You?
Handguns.
Handguns. 70, depending on which state you're looking at. In Connecticut, if you go back 20 years, the weapon of choice for criminals in commission of crimes of all stripes, either homicides or violent gun-related crime or crime in which no violence was inflicted, is the handgun. Shotguns and rifles being largely impacted by the new assault weapons ban, are about 7%. 7%. Okay. Mass shootings. Mass shootings. The reason the legislature is looking to deny and violate this right. Mass shootings are less than 1%. Less. I don't even think you get to half of 1% of all crimes committed in this country. They are classified and quantified by anybody who studies the subject. But what was Mr. Coker's great phrase, Chris? Extraordinarily rare? Extraordinarily rare. Extraordinarily rare. So even though we have these tragedies, these unspeakable, unspeakable tragedies, the Navy Yard, Binghamton, Aurora, Newtown, they are but a handful of the violent crimes committed in this country. More importantly, police studies and congressional research studies, which are extremely reliable, tell us that these events are essentially unknowable. They can't be profiled, they can't be prevented, because the perpetrators tend to be loners. They don't act in concert. They don't communicate with anyone. They don't share their plans with anybody. You cannot analyze them for pattern because the victims are picked at random. The shooters do not telegraph their behavior. And they are typically killed before they're caught. So the police can't talk to these guys and gather information from them that would allow the police to develop a database or a pattern body of knowledge that would give them the tools, as they have in many, many other areas, you know, to go out and prevent these things from happening. You can't surveil these guys. You can't look at them on a website. They're not like Al-Qaeda, and they talk about what they're going to do. They pick their victims at random. With the exception of being white and male, there's very little that they have in common. They're not motivated by some sort of political or philosophical idea. They're not going out and kill. The guy in the Navy Yard wasn't killing anybody because he wanted to, stop the war in Iraq. James Holmes didn't go into that movie theater as a protest in support of the First Amendment. Adam Lanza was not trying to make a point to anybody. So these events are, from a practical standpoint, unknowable. So what's the harm? What's the point of all this? What's the point of all this? They are using extraordinarily rare, infrequent, non-representative events to alter and change a fundamental right. Does that make sense to you? Yes, ma'am.
How many gun laws is there actually?
How many gun laws are there?
Yeah,
Well, I think, when I think of regulation, I can't think of a more, with the exception of pharma and tobacco, I can't think of an area that is more overregulated than the area of guns. Tobacco, medicine, and guns. Understanding, and now I don't know the answer to your question specifically, but there is a very extensive and detailed body of federal regulation beginning in 18 U.S., well, not beginning, but including the Gun Control Act, the National Firearms Act, the Firearms Owners Protection Act. They're codified in various parts of the federal statutes. What springs to mind is, to me, is 18 U.S.C. 922, which outlines federal firearms licensing programs, disqualifying factors, background checks, the assault weapons ban that's now expired, federal assault weapons ban that's now expired. And then you have the states, who are free to regulate, up until recently, as much as they wished, at their own level. So there's a lot. It's my very undisciplined and uninformative answer, and I'm sorry I can't answer your question in more detail, but there are many. But anyway, so now you have legislatures reacting to popular outcry to horrific tragedy. But tragedy is nevertheless rare, even in this age of media saturation. Still, nevertheless rare to define and limit what has now been described as criminal. In Connecticut, that has taken this form. The Connecticut Act does many things. It broadly defines, it more broadly defines the species of firearm described as assault weapon. It limits the number of rounds that can be placed in a magazine, an ammunition magazine. It creates a permit system in order for people to continue to possess firearms now classified as assault weapons that were previously lawful, that are now being impacted by this law. It restricts the ability to purchase ammunition. It does many other things. It impacts mental health care providers, reporting requirements. It alters licensing schemes to obtain firearms. And we are not challenging all aspects of the law. Yes, sir.
It's also impacted the economy and businesses leaving.
Well, it certainly is doing that. That's not. Some would argue that was exactly what Governor Malloy intended, but it is. It has the result of harming or driving arms people in the entities that do business in the firearms and shooting enthusiast industry, either out of business or out of the state. In Connecticut, there is Stag Firearms, Colt, very popular, well-known firearm manufacturers who manufacture the firearms, the magazines that are impacted by this law, and those are big manufacturers. There's also a host of small ammunition stores, gun shops, outdoor outfitting, mom and pop type places, mid-level places like Dick's and Cabela's and Gander Mountain, and then you have the mom and pop places that have been business on the corner for years, who, gunsmiths, people who sell rifles, shotguns, pistols, all of the accessories that go along with those things, and they're being driven out of business. Now, the more cynical amongst us would say that is exactly what the legislature is trying to do. The more cynical amongst us would say this is not about a constitutional right, this is a culture war. This is an assault by an unknowing legislature in a knee-jerk reaction to a horrific tragedy to drive a specific culture out of business and out of existence. That's a cynical view. Those on the other side would say this is a necessary response to an epidemic. There's an epidemic of gun crime in this country. This can't go on. We can't have another mass murder. And, ladies and gentlemen, I agree. We can't have another mass murder. Who would ever want something like that? Who wants that? Nobody does. But the pro-Second Amendment enthusiasts would say that this is an unreasonable and overbroad response to a situation that doesn't involve a weapon, which everyone understands, or firearms, everyone understands can cause harm, but it really should be aimed at the individual who picks up the weapon and uses it unlawfully. In other words, you can't punish the many for the crimes of the few. You cannot violate the rights of the citizenry because criminals decide to break laws. So, to be very balanced with you, and guys, there's no secret who I am. I walked in with Chris. I'm lead trial. I'm plaintiff's counsel in two states. Everybody knows which side of this argument I come down. But let's just understand. The proponents of these laws claim that weapons that are classified as assault weapons are military features, are military firearms. That they have no sporting purpose, they have no commercial purpose, they have no personal self-defense purpose. They are firearms used solely for the purposes of military attack on individuals, and the features which constitute banned features are military-style features. That they have no legitimate purpose for self-defense, they have no sporting purpose, they have no personal use purpose, and therefore the firearms that are not affected by the law are sufficient to allow those who want to exercise their Second Amendment rights to defend themselves, to compete in sporting competitions, to defend their hearth, their home, their property, to hunt. And those on the other side say, you are absolutely wrong. None of these features are military-style features. None of these, the majority of these firearms, the ones most commonly impacted by this legislation, are the most popular firearms in this country. The features that are banned by them are commonly used by millions of law-abiding citizens for legitimate purposes like hunting, like sporting competitions, most importantly, for the defense of hearth and home. And that is the debate. Yes, ma'am.
So if you're licensed to have a gun in your home and somebody decides they want to rob you, you have the right to shoot them? And like,
You have the right to shoot them.
versus if you didn't have your license and you had a gun and somebody tried to rob you and then you tried to shoot them, would you get in trouble, or would it still be like?
Well, you
self-defense?
certainly, you have to have a permit to have a firearm. In the state of Connecticut, there is a permit requirement, and no one on our side of the argument is saying that you shouldn't have a permit. So, keeping with what we're here to talk about, the plaintiff's theory in Shoe, one of the several theories in Shoe, is that the ban on the expanded definition of assault weapons and the ban on the ability to possess an ammunition magazine that holds more than 10 rounds violates your fundamental pre-existing right to self-defense, to protect yourself in your home. There is a greater debate, a split among the circuits, as to whether the core Second Amendment right of defense, possession of a firearm in defense of self, home, and property and loved ones extends beyond the home. That's not directly an issue in the Shoe litigation, nor is it directly an issue in the SAFE Act litigation in New York. But a very key argument is, we know the right, according to the Supreme Court, the core right exists in the home. How far does it exist outside of the home? The common sense argument says, well, there are many circuits that say it doesn't. That you lose your Second Amendment right the minute you step outside of your house or your place of business. There are many circuits that say that. New York, Second Circuit, within which Connecticut resides, firmly says that. The Seventh Circuit, with those great progressive judges in Chicago, say that. I believe the 11th says that as well. The 4th.
The seventh.
Seventh.
It is right outside the home.
Okay, but there's a split. The Fourth Circuit says, of course it exists outside the home, because the right of defense exists outside the home. If you're in public and you're attacked, you have the right to defend yourself. The Second Amendment was written and brought into existence at a time when people needed to hunt to survive, to obtain their livelihood. The militia by itself is a public function. It doesn't happen in your living room. It happens in the public square. Of course the right exists outside the home, and everyone knows that. You hunt in the forest. You don't hunt in your living room, unless you live in the forest. But the point is, or if your living room happens to look like a forest, which could be my living room. But the point is, there's a very real debate about the extent of the right. We're not litigating that right in shoe. That split may be a good reason why the Supreme Court takes up the case, to make a broader statement about the nature of the right. However, the plaintiff's argument is that you're limiting the ability to defend yourself in very important ways. To follow up on this young lady's question, where the guy breaks into the house. We begin with the fundamental proposition that criminals, by definition, don't give a crap about the law. They are not going to be bound by gun regulations. They're not going to be bound by universal background checks. They're not going to be bound by the need to get a certificate of possession, as Connecticut requires. If they have a grandfathered firearm now classified as an assault weapon, they're not going to declare it. They don't care. They're going to use whatever's at their disposal to get what they want. Should anybody break into your home, the limitation on the ability to effectively defend yourself is violated because you can't possess more than 10 rounds of ammunition in a clip, in a magazine. Yes, sir?
Isn't that in your home you can load them full?
No. No. You
I
can't.
thought in a home or at a range you could load the magazine full.
For certain people are exempt from law enforcement, but no, you can't load a full clip, a full magazine in your home.
Really?
Really? So there are obvious factual scenarios that support that argument. One of them being, suppose someone breaks into my house carrying a semi-automatic firearm with a 30-round clip. Is the right to meaningful self-defense? Is the right to self-defense meaningful if I can only carry a firearm that does not have equal firepower? In other words, and this is an undisciplined argument, I'll make it very simple, is the new law forcing me, in effect, to bring a gun to a knife fight? Now, a lot of this depends on an individual's knowledge of firearm use. You sir, seem to know something about firearms. I don't know if you do or you don't, but one of the challenges that litigants face is we have to educate a judiciary that may or may not be knowledgeable about firearms. We certainly are trying to refute a legislature that we believe knows nothing about firearms. Because if they did, they wouldn't pass laws like this.
Now, Attorney Stapleton, be careful, because we're going down state senator.
Well, you know what? So yes, and ladies and gentlemen, this is an adversarial. Litigation is by nature adversarial, but it is not hostile. It is not hostile and it is not disrespectful. I'm privileged in this litigation, very privileged, thanks to Chris, to be working with some of the leading, if not the leading, Supreme Court advocates. One guy in particular, his name is Stephen Holbrook. He has argued and won in front of the Supreme Court on Second Amendment and other issues.
And he's actually written a book, a really good book called Freedmen, the 14th Amendment, and the Right to Bear Arms.
He's written many good books.
It's almost like the
Right.
Bible on this.
Well,
Yeah.
he's written several books. And we work together. Several lawyers are part of the team, and we are trying in New York and in Connecticut and in Maryland and in Illinois to create a body of law that will be litigated up through the circuit courts and hopefully be addressed by the United States Supreme Court. We don't know if that's going to happen, but we feel there's a chance. Yes, ma'am.
So, let's just say you win in Connecticut, it goes up.
Right.
And the Second Circuit says, yeah, you're right. Now, the seventh is the New York one?
No, New York.
I just wanted to say, wherever you're doing your other cases in a different.
No, it's also the Seventh
Oh,
Circuit.
So let's say the Seventh Circuit says it's pretty much the same case and they say no.
Right.
So, does it automatically go?
No.
Or does it still have to?
It does not automatically go. What happens is at the appellate level, the losers would file what's called a petition for certiorari, petitioning the Supreme Court to please review this case and issue a decision. The Supreme Court either grants or denies the petition, and then the case goes up and gets put on the Supreme Court calendar and is argued in front of the Supreme Court. So,
But what I was getting at, what you were practicing for, is this case is coming up for oral argument in
Yes, it is.
December, right?
it is.
And so what are you gonna, I'll just ask this one last question, because I want to get the procedure in, so they kind of put what you're saying in context.
Right.
So what's happening in October?
Okay, so we have gone ahead and in Connecticut, we as the plaintiffs have filed a motion for summary judgment. So we have filed a complaint. I believe you have a complaint as part of your course materials. Our complaint seeks injunctive relief and a declaration. So the injunctive relief is asking the court to say to Governor Malloy, the legislature, and the police force, you are ordered to stop prosecuting people for violations of the SAFE Act. I am ordering you, and courts can do this, I am ordering you to stop, I am striking down, and I am ordering you to stop prosecuting people for possessing more than 10 rounds of ammunition in the home. I am ordering you to stop prosecuting people who may possess semi-automatic firearms that have criminal characteristics. I am ordering you to allow these people to do these things. I am at the same time declaring that these provisions are unconstitutional as being violative of the Second Amendment, the Equal Protection Clause, and that they are unconstitutionally vague. We are not challenging all parts of the Connecticut Act. We are only challenging the parts that we feel give us the greatest chances of success. There are many parts of the Act that the citizenry find offensive and claim to be and believe to be violations of constitutional rights. We are not challenging all of them. Why? Because in a litigation world, you have to pick your battles wisely. You have to choose those fights which you believe you have the best chance of winning. And you have to look at legal precedent, historical precedent, to see which kind of challenges have won in the past and which we believe will win in the future. So we have a motion for summary judgment. We have, on our complaint, we have now moved to have the court give us what we want. We're doing this in a very fast, expedited fashion. We will have, the state is in the process of opposing. They will file their opposition papers quite soon. We will reply to that, and then once all the papers are in, Judge Covello in Hartford is going to have an argument. And we will appear and argue, and I will argue. And then he will give a decision, and based on whatever his decision is, we will then, if we lose, or the state, if they lose, or both, if, he might, if both don't like the decision, both will appeal. Judge Covello doesn't have to, it's not an all or nothing proposition.
Does it get pretty heated in here?
No, as I was saying, no, it shouldn't. This is a civil court of law. And civil meaning non-criminal, but civil meaning also civil. And so my point before was it's adversarial and not hostile. Peter Cook laughs at me. But it's not name calling. It's not personal. We disagree with what Governor Malloy has done. He disagrees with our position. A civil justice system is designed to foster the dispute resolution in a manner that doesn't involve fighting. So we have a lawsuit. I mean, I don't know the people in the Attorney General's who are handling this case. I've gotten to know them a little bit, but I don't know them very well. During the course of my years as a litigator, I'm sure Rachel and Chris will say the same thing. I have had heated battles in court and ended up being very close friends with the guys and the women I opposed. It happens. And there's sometimes it's not always the case, but it's not heated, and nor should it be. It's not the way this issue gets resolved. So we are saying that the definition of assault weapons is improperly broad, that it impacts millions of firearms that are typically possessed by law-abiding people in common possession, in common use. The one firearm that we say is most dramatically impacted, although by not means the most impacted, but the sort of, I guess, poster arm for this fight is the AR-15. The AR-15 is not a particular brand. It is not a particular model manufactured by only one firearm manufacturer. It is a type of firearm. It's what we call a platform. It is a semi-automatic rifle as opposed to a shotgun that possesses certain characteristics. It is semi-automatic. It typically has a telescoping stock. It is capable of accepting a detachable ammunition magazine. Commonly, and most are manufactured as standard magazines that possess that hold at least 20 rounds. And you went like this, and rightfully so. What I think most people on the anti-Second Amendment, or what I would call the uneducated Second Amendment side of the fence, they're not necessarily against arms, but may not understand what they have called large capacity magazines are standard. Most semi-automatic rifles, certainly the AR-15 platform, come out of the factory with the capability of accepting only magazines that accept far more than 10 rounds, typically 15, 20, 30. And sometimes more. Yes, sir.
Question on that. With what you just said prior to that, you said that the lawyer was in the process of only allowing 10 rounds, or also
No, I didn't say that.
was just a.
No, you were allowed to possess more than 10 prior to the law. Now you cannot.
But that's what I'm saying. Now you can't even have 10, but they make these guns with clips that allow 20. Like how? And the other thing is, when it's used for just recreational or hunting or sport, now you can't do that.
No, you can't. You cannot. You cannot. And hold one. These are what?
You got to register anything over a 10-round magazine in the state of Connecticut by the date. If you do not, then you're in trouble with the cops.
If you don't, you're a felon.
Right, that's a felony.
Right. You're a felon. So we are saying that this definition, which outlaws semi-automatic firearms capable of accepting detachable magazines that have certain characteristics, such as a telescopic stock, a grip that allows your hand, the hand with the finger trimmer, to rest beneath the action of the firearm. This definition impacts what I know with virtual certainty is the most popular sporting rifle in the country. Going away. We're not talking about it's a close call. The AR-15 platform is the platform of choice for police officers, military personnel, sporting enthusiasts, to the tune of millions. Millions. It's not close. This really isn't an argument. I mean, you can make it an argument, but it's not really an argument. The numbers show that this particular firearm is the firearm of choice. Why? I'll get to you in a second. Why? It's light, it's easy to use, it's accurate, it promotes safe and responsible firing. I don't know about expense, that's not really an issue or a factor, but when you talk about Heller's dictate of the Second Amendment protecting firearms that are commonly possessed, typically used for by law-abiding citizens for legitimate purposes, you are talking about the AR-15. It's used to hunt. There's a species of firearm called the varmint rifle, which looks just like an AR-15. It is an AR-15. It's got a threaded barrel, it's got accessories, it's got a detachable magazine, it's got a telescoping stock. It's used in sporting competitions. It's used by colleges for sporting competitions. It's used by gun clubs across the state in 3-gun matches, 2-gun matches. Citizen marksmanship program. Just 1 second, okay? It's used everywhere. It is, and if you have ever had to, or if you've chosen to, go to a range and shoot a shotgun, which is what the governor and certain proponents of this law would say you ought to be shooting. Pick up a shotgun, try to fire that, and then pick up an AR-15 and fire that. It's like going from a Hyundai to a Maserati. The difference is night and day. The ability of a person of small stature to pick up and load and handle a Mossberg shotgun, which weighs probably 3.5, 4.5, maybe 5 pounds more than an AR-15. Pick it up, load it, aim it, and shoot it without getting knocked 4 feet backwards in your home, while trying to incapacitate someone without hitting anybody else. The ability to do that with a firearm like a Mossberg, which is a fine firearm, but a heavy, unwieldy shotgun, as opposed to a light, utilitarian firearm like an AR-15, is you can't even argue the difference. Military people, the FBI, recommends as the self-defense firearm of choice the AR-15 chambered in .223 or 5.56 ammunition. Why? Because it's easy, it's safe, you don't get the downstream, down-target collateral damage, there's no over-penetration. This is all gun guy stuff. But we're talking about guns. And we're talking about a law that violates the rights of gun owners passed by people who we believe don't even know about guns. Or if you look at this law, they don't know much about guns. So the assault weapon definition impacts firearms that are commonly used, typically possessed for law-abiding purposes. That's what we say. To the tune of millions in Connecticut and across the country. The limitation on the ability to load more than 10 rounds in your home likewise violates your right to self-defense. Why? Because statistics show that even the most highly trained police officers in armed confrontation within a range of 10 feet or less will shoot at and miss their targets. So if a trained police officer, or someone with military background who buys into the idea that they're going to be in an armed conflict, goes out and is prepared, at least mentally, to meet that conflict, has been trained to meet that conflict, has the equipment to meet that conflict, and the signed-on duty to do that, expects that to happen. That person, when faced with an armed assailant, will shoot at and miss the target. Guess how often? Guess how often?
9 out of 10.
Not much, but they're going to fire more than 10 rounds 32% of the time. The logic being that if a trained police officer needs to fire more than 10 rounds to not kill, but incapacitate an assailant 33% of the time, average Sue Smith, woken up at 3 o'clock in the morning when there's an armed or somebody in their house coming at them, is going to be nervous, is going to be untrained, will not be able to load that firearm quickly enough to defend herself or her children in a meaningful fashion, will fire at and miss the assailant more often than 3 out of 10. And therefore the need to have more than 10 rounds in your magazine is very real and is a violation of the right to defend yourself. That is one of the arguments. That's one of the arguments. Yes, sir.
I have a question, and I think that it benefits them. Shu v. Malloy is challenging portions of the recently enacted firearms statute.
Yes.
And you made a statement that I agree with, that our legislators in Connecticut probably don't understand firearms or firearms laws that exist.
That's a personal belief. I don't know the
No.
legislators, but it's a personal belief.
Mine also. My problem with the whole process is, and I don't know if your lawsuit will look into it, is I'm willing to bet that individual legislators did not draft this legislation.
Oh, I think there's no question.
They put it out to people. They said they had this red, blue ribbon panel. But I believe that somewhere along the line, law enforcement had a lot of input into whispering in people's ears. Will your legislation, will your litigation bring that out?
We're not challenging the manner in which the law was passed, so no. Although I believe that legislation like this, particularly when compared to other legislative acts, the SAFE Acts, other things going on, there's earmarks of similarity that makes me think that there's a think tank or some organization or group of organizations that have the ear of the executives that push this stuff out and that they use it as a template and they modify. I mean, do I know that for a fact? No, I don't, but I strongly believe that. I strongly believe that.
Is there a challenge over the use of the Easter process?
No, not in our litigation. Mr. Cook has some very strong opinions about that, and I'll talk about that. We talked about this at the CCDL meeting where I presented just a little while ago. We are not challenging the registration process, although we find it very offensive. We are not challenging. The e-cert or the e-cert process, in my view, is very tough to. It's extremely offensive, but it's very tough to challenge. It really, quite frankly, pisses a lot of people off. I mean, it's a midnight run, but courts traditionally do not interfere with a governor's determination on what is an emergency or not. That's a separation of powers issue. Courts generally. Yeah, there is. The NSSF is bringing a suit on that. We looked at it, we whiteboarded it, we decided not to go with it. But doesn't mean it ain't gonna win, or could win. So it's 12 o'clock. I'm gonna let Chris stand back up. That's the lawsuit. Thanks for listening. Thanks for your questions. I'll talk to you guys afterwards.